Hello, and welcome to California Gun Law. I'm your host, Don Hammond. On this episode, I'm going to talk about California's laws regarding brandishing, what it is and what it isn't. I'll dispel some common misconceptions and provide the legal definition of brandishing. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearms laws and regulations, and there are lots of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll discuss brandishing a firearm under California law. Many people have questions about brandishing versus printing or displaying a firearm. California's brandishing law is found at Penal Code Section 417. It applies to all kinds of weapons, not just firearms. In addition to guns, I've had brandishing cases that involve knives, metal bars, and reciprocating saws. But for this video, I'll primarily focus on the law as it applies to firearms. Brandishing is usually a pretty serious misdemeanor with mandatory jail time for a conviction. If you brandish a firearm on the grounds of a daycare or in the presence of a peace officer, it can be a felony. But just because someone can see your gun doesn't mean that you're brandishing it. To be convicted, the law requires the government to prove that you drew or exhibited the firearm in a rude, angry, or threatening manner. So when someone notices you printing through your clothing, that's not brandishing. Or when you reach to the top shelf at the grocery store and someone sees your gun, that's not brandishing. It's also not brandishing if you display a gun in self-defense. However, you must first have the legal right to use the gun in self-defense. So unless you can articulate a threat of death or great bodily injury to an innocent person, don't draw your gun. If you draw to win an argument or scare someone away, that may be an illegal act of brandishing. Even in the heat of a yelling match, if there's no immediate danger, you can't draw your gun. Of course, you shouldn't get into a yelling match in the first place, especially while carrying a gun. Brandishing a gun, whether loaded or unloaded, carries a minimum county jail sentence of 90 days in the state of California. There's also a fine line between brandishing and assault with a deadly weapon. If you merely display a gun in a rude, angry, or threatening manner, that's brandishing. However, if you point it at someone, that becomes an assault with a deadly weapon, which is generally charged as a felony under Penal Code Section 245. And if you fire it at someone, that may be charged as attempted murder. If you are charged with brandishing, there may be ways to avoid a conviction. One way is to prove that you displayed the gun in self-defense. Another way is to enter into a diversion program. I've gotten diversion for several clients in brandishing cases. Diversion means that you complete some terms and then come back to court and the case is dismissed. No conviction, no jail time. The terms may include anger management classes, gun safety classes, counseling, community service, or anything else that you agree to. Types of diversion that may be available in a brandishing case, depending on the situation, include informal diversion, judicial diversion, mental health diversion, or veterans diversion. But the bottom line is, keep the gun in your holster until and unless you're sure that you need it to defend yourself. But it's not brandishing if someone happens to see it, so don't worry about printing. That's usually not a crime. Most people are too consumed in themselves to notice a bulge in your waistband anyway. And a good holster helps. Here's a picture of me on a recent hike with a group of people who had no idea I was carrying. I was concerned about posing for this picture because I thought people might notice that I'm carrying, but it turns out that my gun is not even noticeable. Let me know in the comments if you can spot it. As a CCW licensee, you have an obligation to keep the gun concealed. That's mostly pretty easy to do, even in shorts and a t-shirt. But if someone does notice it, you're unlikely to face criminal charges. I'm Don Hammond at California Gun Law, and we'll catch you all next time. Stay informed, stay legal, stay safe.